Hey everyone, Harry here to talk about the decision of an Illinois court to strike Trump from the ballot. The actual finding is he falsely certified that he was qualified to be on the ballot, whereas he wasn't because he engaged in insurrection, having sworn an oath, everything about the 14th Amendment that's in the Colorado case. And that's the first point here. If the Colorado case hadn't gone up to the court and hadn't been heard, this would be a pretty huge development. Illinois is one of the most populous states in the country, and it would have been the most that had considered things. Instead, it's noteworthy for a few reasons, and that's what I'm doing here, and I'll explain it to you, but it's not momentous in the same way because it's pretty clear. Indeed, the judge herself made it clear that all of this is subject to what the Supreme Court says when it rules in Trump versus Anderson, the Colorado case. And as an aside, everyone expects, including me, and I was at the argument, that the court is going to rule one way or another. That's a little bit of the suspense for Trump, and that the challenge under the 14th Amendment just is not going to succeed. All right, back to Illinois. Here's how, it's an interesting point. It's one of the reasons that Supreme Court of the United States is wary of letting states just do what they will, because they do very different things, and you could have a very kind of patchwork quilt. Do they decide things by what standard of evidence, and what evidence do they receive to make these determinations, and under what's the standard for reviewing it, and the like. So in Illinois, there's a hearing off. It all starts administratively. The Board of Elections makes a decision, and that board is advised by a hearing examiner. And here the hearing examiner heard and took evidence, etc., and advised the board as follows, and the board accepted the recommendation. The hearing officer said, you are not supposed to do constitutional analysis. That's just Illinois state law. You're here to administer the elections code, but not to substitute what Illinois courts do by telling us what is due process, what is equal protection. And well, here, what you're being asked to do by citizens who are challenging Trump's candidacy is constitutional interpretation. What does insurrection mean in the Section 3 of the 14th Amendment? And what does, having engaged in it mean, and the like? So I advise you, Board of Elections, that you cannot you should dismiss this petition, effectively holding for Trump. However, if you don't, the hearing examiner said, from the evidence, etc., I got to tell you, my recommendation to you on the evidence is it fits him like a glove. He engaged in insurrection. So, an important point here is nobody who's considered this on the facts has held for Trump. Everyone who's thought about it said this is engaging in insurrection, and that's pretty darn significant. But so he says, and if you disagree with me on my point about the whether you can do constitutional analysis, I recommend to you on the facts that you find Trump fits the criteria under Section 3. That is to say, he is disqualified under Section 3, and you should bounce him from the ballot. The board accepted what the hearing examiner said, and under Illinois law, it then went to the courts. And what we got yesterday was the decision of the first level of Illinois courts, the state court level. And that court, and as I said, up top, it would have been a really big deal, but for the courts already having heard the case. Oh, and another little thing happened in the Supreme Court as well that also swamped things yesterday when they took the case on immunity. But that this judge went through it when all the pretty long opinion, sort of laborious on standard of review and that kind of stuff, but basically said, you know what, the Colorado Supreme Court is right on the facts. Judge Porter, who's the trial court judge, basically said, said, she's not required to. It's not a binding precedent. It's the Colorado court, and she's an Illinois state court judge. But she said, they persuaded me. I think it's right. That's a summary of a much longer discussion. But she basically says, again, he engaged in insurrection. He's not qualified to be on the ballot. Therefore, when he attested to be on the ballot that he was qualified, that was false, which is a pretty sharp way to put it. But so he is off. That's my holding. And that holding now itself, would normally go up the chain in Illinois courts. She said, that's my holding, and I'm going to stay it for 2 days until Friday, so Trump can try to get appellate relief. But if he doesn't, that holding is, the state of law in Illinois. But of course, she also understood and said expressly the holding, to the extent it's inconsistent with anything the Supreme Court will say in Trump versus Anderson, then what the Supreme Court says goes. So that's the other reason that this holding could be displaced. It's an interesting point. You could have a state court judge saying, we don't care what they say in about federal law in the Colorado case. We're talking about state law, and under our state law, he's off the ballot. And that would create a more pitched battle than the court exactly has taken on in Trump versus Anderson. But that's not happening here. And indeed, all the way through, including from the courts that haven't decided it, there's been a recognition that, if the court takes this case, which it did in Trump versus Anderson, whatever way they rule is going to stand for the nation. You could have debated that proposition, but that seems, as a practical matter, where it's coming out. So Judge Porter says you got 2 days to challenge this, and we will not get Trump versus Anderson in 2 days. So I think he's going to have to try to get a stay, although he could just be rolling the dice, knowing, being pretty confident he'll win in the Supreme Court, and that will, by force of her own opinion here, Judge Porter's, dislodge it as well. So really, it's on the one hand significant that another judge looks at things and says there is he's disqualified for all the reasons the 14th Amendment says he should be disqualified. But it's a little bit of an asterisk, because we know that it's not going to change. In fact, it itself will change based on what the Supreme Court says. So to the extent the Supreme Court's decision is going to be taken as settling this question nationally, nothing about Illinois state court decision here changes it. But the process could nevertheless go forward to the appellate. There are 3 levels in Illinois. This was the lowest. You could have the medium up to the Illinois Supreme Court, or they could just say, let's just cool our heels and see what the Supreme Court says in Trump versus Anderson, because that's what's going to determine things. I think more than incidental that this judgment has been made and reinforced, and every court that has considered on the merits has done so. But in terms of practical impact, basically nothing, because it's just remains the case that what the court says when it issues its opinion in Trump versus Anderson is what will apply nationwide. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.